All right. Good afternoon, everyone, and thank you all for joining us for today's A Month of Service presentation of evictions and knowing your rights. My name is Nia Murray. I am the programs coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the A Month of Service collaboration. Also included is the City of Houston's Department of Neighborhoods, and joining us today we have Miss Cecile Carlson. In addition to that, our presenting partner today with Lone Star Legal Aid representing, we have Mr. Benjamin Daly, who will be providing the information for you all today about evictions. Also included in our partnership, however, is the Earl Carl Institute, Texas Legal Services Center, Houston Volunteer Lawyers, the Harris Central Appraisal District, and the Harris County Tax Assessor Collector's Office. And together we make up a month of service. And basically, a month of service is the collaboration of all of our organizations coming together on a monthly basis, offering information and resources to the community relative to community empowerment, asset protection, asset building, and the maintaining of generational wealth. We've been doing these presentations collectively for the past several years, or actually since 2018, 2019. And we decided to come together in a collective effort to try to reach more people, get more information out to the community, and create a larger impact. Adjusting to the virtual platform, we have been able to reach people from not just the city of Houston, but surrounding counties and across the state of Texas. So it has allowed our collaboration to expand on the different topics and things that we've had over the last several years, including about information about eviction, especially with changes that are coming into place. We generally can't keep up with a lot of that stuff, so we do rely on the experts like Mr. Daly to provide these updates to you guys. So, which is why we have these on a monthly basis so that you can get the most up-to-date information as it relates to the laws in the state of Texas. Um, do know also that the information that does get provided here today is for educational purposes only. It is not to be considered legal advice. However, if you are facing any kind of an eviction or find yourselves in need of any civil legal assistance, we do encourage you to reach out to our legal service partners like Lone Star, Earl Carl, and the Houston Volunteer Lawyers for some professional assistance in your in regards to your personal situation. Do you know this is your opportunity to ask questions of the expert that we have here today? However, we are on a live platform. We also broadcast live on our social media pages. So we do ask that you try to keep your questions to be as general as you possibly can. We want to try to protect your privacy as best we can by not divulging any personal detail information about your specific situation. Again, because we are on a live setting as well, or a group setting, um, you know, your information we is privileged information that we don't want to get out there. So let's just say that. So do keep your questions to be general, but we do want to get your questions are addressed, but just kind of formulate them in the broader kind of text. So with that being said, there is a lot of information that we're going to go over here today. And we want to thank you all for being here, for continuing to support a month of service collaboration. Or if you're joining us for the first time, we want to welcome you and thank you for being here today. So without further ado, we're going to go ahead and go into our word introductions and then get right on into the presentation. So Cecile, will have you introduce first, and then Benjamin will have you introduce, and then you can go on into your presentation. So.
Thank you so much, Nia. Good afternoon, everybody. My name is Cecile Carlson. I am the outreach coordinator here at the Office of Neighborhood Engagement with the Department of Neighborhoods. And like Nia said, we are one of the collaborators in the AIMless partnership. We want to welcome everybody and thank you guys for being here. We also want to thank our presenter today, Mr. Daly, for being here and providing very valuable information. I love these classes because we get information straight from the subject matter experts, people that know what they're talking about. And so make sure to ask those questions in the chat. And again, thank you so much for being here.
Okay. Since Cecile did bring up the chat, let me just say this. For those folks that are joining us on the Zoom, you can type your question into the chat or feel free to unmute yourself at the end and ask the questions directly of a presenter. If you are joining us on our social media platforms, feel free to type your question into the comment section and I'll make sure that it gets addressed or read aloud at the end as well. So with that being said, Mr. Daly, go ahead, take it away.
Okay, thank you so much. So my name is Benjamin Daly. I'm an attorney with Lone Star Legal Aid in our eviction unit, and this is Evictions Know Your Rights. Before we get started, special acknowledgement to Kim DK, who created this presentation. A little bit about our firm. We are a 501c3 nonprofit law firm. Our primary reason for being is to represent low-income individuals in a variety of civil legal matters. We have both specialized units, such as the eviction unit, but also general units for specific populations, such as veterans. And we can offer assistance with everything from getting simple advice about your case and your facts to full representation. I'd be happy to provide more information at the end on how to apply. This is our agenda for today. Some things to keep in mind. First is that we're going to be providing general information. Be aware that in a lot of landlord-tenant disputes, facts are what the case turns on, not the law, but specifically what happened. So just be aware if you have any questions specific about your case and you need assistance, please apply for help. Additionally, generally, if you're thinking about filing a lawsuit, we recommend speaking to an attorney before taking any of those steps. Additionally, something to note is that what we're going to be talking about today is based on the law as it exists today. We just got through with a legislative session, though, and the legislature changed the property code in a lot of ways that are going to affect the information we get. So just be aware that if you're watching this and it's towards the end of 2025 or into 2076, you may want to find a different presentation on these issues. Getting into the heart of the matter today, first place to start is on lease agreements. A lease is an agreement between the landlord and the tenant. It's going to be what establishes the tenancy, which is your right to have possession of the premise. All leases are contracts, if that makes things easier to understand. Texas allows for both verbal and oral leases, as well as written leases. If you have an oral lease, we recommend that you take steps to document the terms of the lease. If you're going to have a lease term, though, that's longer than a year, that agreement must be in writing. Under the property code, you have a right to a copy of your lease within 3 days. If you don't receive a copy of the lease, you should ask for it in writing. If you still don't get it, that's time to talk to a lawyer about possibly filing a lawsuit. Important to know about leases. Because the lease agreement is the contract that is going to provide the right to possess the premises, the lease is going to contain terms that usually control in disputes. Additionally, the legislature has made leases very powerful instruments in terms of defining the terms of the tenancy, which means that the lease can change timelines that would otherwise be provided by the property code. The lease can also waive rights that would otherwise be provided to the tenant under the property code. So be aware, lease is very important. If you're dealing with any sort of dispute, it's the first document you should look at. To get more specific in terms of what you're going to find in a lease, make sure you're reading over it and make note of these important clauses. So first is the lease is going to establish the rent. It's going to tell you how often the rent needs to be paid. Most leases are going to require monthly rent, although some will require shorter period of times or may require a longer timeline in terms of making payments. So for instance, there are some lease agreements that require weekly payments, smaller amounts. I haven't seen one, but I'm sure there are leases out there that require bi-monthly rent or some larger form. So it's important to know how much the rent is, how often it is to be paid. It's sometimes specific about where and when to make payments. So for instance, if you have a lease agreement that says that you're supposed to provide your landlord a money order on a specific date or to mail it in a specific way, the lease will tell you that information. The lease will also tell you if there are any penalties for not making the payments timely, such as late fees. And it's going to provide information about how payments are to be applied. Many lease agreements that both require the payment of rent, but also require payment of utility or other sums, have clauses that say that the payment can be applied however the landlord sees fit. So if you want to pay your rent first, but don't want to pay utilities, and you hand over a check just for the rent and label it rent, the landlord in those lease agreements could take it, apply to utilities first, in which case at that point you'd be behind on rent. A lease agreement is going to establish what the initial lease term is. Usually we see, we call it leasing years, which basically means that it's for a set period of time. However, there are also month-to-month leases where basically the lease only lasts a month, but is regularly renewed. It may contain information about what happens at the end of the initial lease term. Many leases automatically renew on a month-to-month basis if the lease expires and there's no new lease signed and there's no termination. Some of those leases also, when they go month to month, will automatically apply month-to-month fees or change the amount of rent to be paid. So it's important to keep in mind when reviewing this, that the terms could change rather significantly if you're leasing at the end of a lease term and don't sign a renewal. A lot of leases have language that incorporates either the signed addendums or community rules and policies. When that happens, any violation of those rules or those addendums are going to constitute defaults under the lease. So pay attention to those addendums and pay attention to the language which incorporates other rules into the lease. Specifically in signed addendums, you're going to want to take note if you're on public housing. So if you have a HUD or HAA agreements, those agreements are going to be incorporated into the lease. The signed addendums could also include concessions, so you want to take note of those. The lease should define what constitutes an act of default. Usually what we see as far as acts of default are failure to pay rent or material breaches of the lease, such as violations of community rules. They may also provide that early termination or holding over could constitute acts of default. And finally, the lease agreement may include language altering timelines. So for instance, if there is a requirement that they provide you a notice to vacate that is 7 days or 24 hours or what have you, that alters the timeline provided under the property code. So pay attention to any timelines that are given under the lease agreements. When we talk about evictions, the first step towards an eviction is the termination of the lease agreement. Terminations can happen in one of two ways. The first way is sort of the termination of the lease at the end of the lease agreement. That is, you have a lease for a year, and as you come up to the end of that, the landlord decides they want to rent to somebody else, in which case they provide you a termination. Or there could be an early termination if there is a breach of the lease, and we'll talk a little bit about that later. The first thing to keep in mind is that the termination of the lease agreement requires written notice. They can't simply orally tell you to get out. They actually have to provide you something in writing. If it is under a lease, if the termination happens under a written lease agreement, the language in the lease agreement could control how much time to be given. If it's orally, usually you're talking about 30-day notice. And if you're talking about a month to month, the statute provides for a 30-day termination notice at the end of the lease agreement. If you get that termination notice and you fail to leave, that's what makes you a holdover tenant. And we'll talk about what a holdover eviction looks like shortly. Sometimes when we're dealing with clients who are facing these issues, there's a question of whether or not the landlord can terminate at the end of a lease agreement, at the end of a lease term. Except in very specific circumstances, you cannot make your landlord renew your lease, just like your landlord cannot make you renew your lease. So keep in mind, if you're talking about termination at the end of a lease term, In most cases, that's going to be a valid termination. So turning to early termination. This is oftentimes what we see at the beginning of eviction cases, not so much the termination at the end of the lease agreement, but there's been some issue and one of the parties wants to exercise their right to terminate the lease. Something most people don't realize is that tenants often also have the right to terminate the lease early under specific circumstances. And so, we've included some of the codes and some of the reasons why somebody might terminate their lease early. Keep in mind the codes that we cite to, those are going to spell out in detail what sort of notice is required and who's covered by the right to terminate early. Some of these statutes also provide a cause of action against landlords who violate these sections, and they specify what sorts of damages might be available. So some rights that you might have to early termination. If you're experiencing family violence, certain sex offenses, or stalking, those can be grounds to terminate early. Those rights can't be waived by the tenant in the lease. If a tenant dies, there is a right for the estate to terminate the lease to prevent future liability, although some past obligations may be required to be covered by the estate. Additionally, certain issues related to military service. So if you're an active service member and you're deployed suddenly, you may have a right to terminate your lease early, although that may be waived in specific circumstances. Again, just to reiterate, if you think any of these apply to your situation, we're going to recommend that you read the code and, if possible, talk to a lawyer. These codes are very specific about what sort of notice needs to be provided to the landlord, and we'll give you some more information about your rights. One final early termination right for the tenants that we want to talk about, because unfortunately we see this a lot in Houston, is what we call casualty loss situations. A casualty loss is basically what happens when there's a disaster that affects the state of the property. So think flooding, think hurricane wind damage, think fire. TPC 92.054 specifies that these rights to early termination come into effect when the property is made totally unusable by the casualty loss situation, and that the loss is not the result of the tenant's fault or negligence. 92.054 specifically provides the tenant the right to terminate the lease in those instances. Keep in mind that same section also provides landlords the right to terminate the lease once the property becomes totally unusable. If you have a casualty loss situation, but the property is not made totally unusable, instead partially unusable, and the loss is not the result of the tenant's fault or negligence, there actually is no right to terminate, but the tenant does have the right to petition certain courts for reduction in rent. Likewise, landlord does not have the right to terminate the lease just because the premises are made partially unusable. Whether a premise is totally or partially unusable is a question of fact for a court to decide. So this is another situation where if you're facing one of these casualty loss situations and you're not sure, you should seek out the advice of an attorney. Please keep in mind too that there are some rights provided in TCP 92.054 that can be waived or altered by the lease. So, read your lease as well as reading the section. It's going to give you more information about your rights. Now we come to sort of the termination that I'm most familiar with as an eviction attorney, which is the termination of the lease due to a breach of the lease. As we mentioned, a breach of the lease or default is defined by the lease agreement. Generally, though, it's going to be any violation of lease term, condition, rule, or other provisions. Some common defaults that we normally see are failure to pay rent by the date stated in the lease, repeated violations of community policies, because again, the lease might incorporate community rules or addendums into the lease, which means that violations of those rules could be violations of the lease itself. Criminal activity, unauthorized tenants, or holding over. Those are all potential violations of the lease that could lead to a termination. Keep in mind, leases and some of the rules that might be incorporated are going to be written broadly in ways that give landlords a lot of leeway in labeling behavior to be a breach of the lease. So for instance, one common rule that we see in conduct-based eviction that's violated is the requirement that the tenant always be courteous and respectful to the staff of the unit. We always recommend that people be polite, just as a matter of course, but that's a very broadly defined rule, and it could cover everything from, committing assault against somebody to simply, swearing at them to simply being unkind to them. And we've seen situations which all of those are cited as a basis to terminate the lease. Some special cases that we see. Sometimes we see people who try to withhold the rent, before an eviction in order to try and get repairs to the property. That's a bad idea. Texas law requires rent to be paid in full and on time as it comes due. Most, if not all, lease agreements are going to be specific in stating that failure to pay rent is a breach of the lease. Even those that don't, like I said, the Texas law requires it to be paid in full and on time, so it's probably safe to assume that any withholding is going to be a breach of the lease. Withholding the rent is the same thing as just straight non-payment. And so that is automatically, like I said, going to be a violation of the lease. It's going to be something that cannot be cured subsequently. Additionally, other than potentially leading to liability under the eviction statute, withholding rent in a situation where you're looking for repairs is also a bad way to actually get the repairs done. Texas law also requires you to be current on your rent in order to maintain your rights. Once you fall behind, including withholding, landlord actually has no obligation to fix your unit. There are rights that you have under the code and other places to obtain repairs. We recommend starting by sending your landlord a request in writing via certified mail. If they don't respond, we recommend you call a legal professional to get advice on how to proceed from that point forward. Keep in mind that counterclaims are not allowed in evictions. A repair and remedy case has to be brought separately. So withholding rent, don't do it. Another case that we often see, unfortunately, is what happens if the tenant goes to pay rent and they try to tender it in full and on time, and it's refused. Landlords are not free to refuse properly tendered rent pursuant to the lease agreement. The landlord could refuse rent if it is late, if it's only a partial payment, or if the lease has been terminated. Keep in mind, the landlord can also determine the manner in which amounts are to be paid. So if there's something in the lease that says that they want a money order and you attempt to take cash, the landlord could be within their rights to refuse the payment. If you're in this situation as a tenant, a few things you need to do. The first thing is you need to be very diligent in documenting everything. Documentation in these cases is critical. The first thing you should do, aside from documentation, though, is reviewing the lease, the current ledger. Make sure that the amount you're offering is going to cover the rent, any and all other arrears, and make sure the payment is offered in a manner consistent with the lease. You want to make sure that the payment that's refused is documented. Make sure you have the date, the time, the manner. You want to keep correspondence with the landlord. This is an area where emails can be very helpful in terms of establishing what sort of communication was going on. So, saying, I have the rent available, I have this amount, sending that creates a record that you might later rely on in court if this does proceed to litigation. You want to keep payment or funds available for payment. Oftentimes we see people who, the landlord refuses the rent and they have other expenses and they use what they would have spent on the rent to pay those other expenses. That is not a good idea. Even if the landlord doesn't accept the rent, they may still be entitled to it under the lease agreement. And so having that available could be very important. If this goes on for more than a month, you want to continue to offer the rent in full and on time for those months as well. So make sure that you're creating a record that not only did you try to pay on this particular date, but you've continued to try and pay. And then finally, but very important, this is another case where you want to contact an attorney for assistance. One final note, sometimes we see a case similar to this where the tenant pays one thing and the landlord says that they're entitled to more money. It's oftentimes better to pay the higher amount and sue over the amount wrongfully collected later than try to pay the lower sum, have it refused, and then end up in eviction court. It's better to put yourself in a position to be on offense on these issues than to play defense. Now we get to, other than lease agreement, the most important document in this situation, which is the notice to vacate. A lot of people don't understand how important this document is in an eviction suit. But a notice to vacate is required to be delivered under the property code. The standard amount of time given under the property code would be 3 days, unless the lease agreement allows for a shorter period of time. There are also some federal laws that require a longer period of time, and we'll talk about those next. A notice to vacate is required in all evictions. It must be in writing. It must demand possession of the property. If you get a notice and it just says eviction notice and it provides no additional information, then that is not a valid notice to vacate. If you get a notice and it says you owe X amount of money, but doesn't say we're demanding you leave, that is also not a valid notice to vacate. The code also specifically requires that the notice be delivered in one of some very specific manners. First, it can either be hand-delivered. Second, it could be sent via regular mail or certified mail. Third, it could be posted on the inside of the door. And fourth, in certain instances, it could be placed in an envelope fixed to the outside of the door. And that needs to be mailed by 5 o'clock on that same day. The landlord has to prove the circumstances that justify this particular manner of delivery in court, if they're going to use it. Right now, notices to vacate is very important that you document exactly how you got the notice. And the reason for that is that if they don't deliver the notice properly, the eviction suit fails, full stop. And oftentimes you see people who, they don't have the evidence to show that the notice was improperly delivered. And even though it wasn't properly delivered, they can't show that it was improper, and they lose in those cases. Whereas had they actually documented it, they would have walked away with a judgment in their favor. So documentation, very important right now. Like I said, there are some federal laws that require a 30-day notice to vacate. The main one is the CARES Act. This provides a 30-day notice requirement for what they describe as covered properties. Those properties are any property that participates in a covered program under VAWA, which basically means that the property gets some form of federal funding through either public housing, Section 8 housing shortage projects, rapid rehousing, low-income housing tax credit properties. There's a long list of these, but basically they're receiving some form of federal subsidy. Their type of covered property are federally backed mortgages. So if the property has a mortgage through Freddie Mac, Fannie Mae, Fair Housing Act mortgage, or something through the VA, then they would also be covered property. Those can include both multi-family units, but also single-family units, such as single-family homes, unit duplex, and mobile homes. So basically, CARES Act, while it's limited to certain sorts of properties, can cover a wide range of housing. Some databases may be available if you think you might be covered by the CARES Act to see if they have your property listed. However, not all of them have been updated. If you know how to check the real property record or request the information through a discovery process or through a Public Information Act request, those are the gold standards for showing that the property is covered by the CARES Act. That said, this is one area where I'd highly recommend that if you think you have this defense, that you talk to a lawyer. First, like I said, some of the databases have not been updated. An attorney is going to have access to better tools to find whether or not the property is covered by the CARES Act. They can also assist in countering any challenges to the validity of the CARES Act, and they can make arguments about how much protection you have under the CARES Act. We're very confident in our reading of the act as presented here. However, there have been some people who have attempted to challenge the ongoing validity of the act or to shorten some of these timelines. And so having a lawyer next to you who can make the arguments that this is the proper interpretation, very important. Finally, we come to the actual lawsuit itself. In Texas, an eviction, the proper legal term for that is we call a forcible detainer suit. An eviction's primary focus is to deal with the right to possess the property. The main thing the landlord has to prove is ownership of the property, breach of the lease, proper notice to vacate has been delivered, and that the defendant has refused to leave. Just as a small aside, pay attention to the date the eviction lawsuit was filed. It is not uncommon to see a landlord file the eviction a day before the notice to vacate expires, and those evictions are required to be dismissed. So just make sure that you're paying attention to those dates. For non-payment of rent evictions, in addition to dealing with possession, the landlord can add a claim for back due rent amounts. They can only ask for the base rent. They cannot ask for late fees, past due utilities, or other sums. In addition to those amounts, landlords could also ask for court costs to be assessed against the tenant and, if applicable, attorney's fees. We often get questions about jury trials and what needs to happen if you want to exercise your right to a jury trial under eviction suit. Jury demands have to be filed and all fees must be paid or waived 3 days before trial. If for any reason you're denied a jury trial, it's important that you talk to a lawyer. They can help protect your rights. So once the eviction petition has been filed and everyone's been served, the first court proceeding is the trial in justice court. Justice courts, they're kind of smaller courts. There are about 16 of them in this county over 8 different justice of the peace precincts. They use simplified procedural rules. They don't have to follow rules of evidence. And so a lot of things you find in one justice court might be very different from what you find in another justice court. Part of the reason for the informality is that these are courts that are intended to be sort of open to the general public. The idea is that any person should be able to go into one of these courts and ask for relief without needing any specific legal knowledge. The reality is a little bit more complicated, but the informality is sort of what dictates this part of the procedure. I know that the slides say that we recommend you arrive on time. I would actually recommend to get to court early. Some courts have community groups which provide assistance or have resources available. Those can be helpful in terms of either getting some form of resolution to your case or getting some resources to figure out your next steps. Some courts are also going to require that you confer with the other party before trial. So getting there early is a good way to sort of start the process in terms of seeing if settlement is possible. We'll talk about settlement agreements next. When you do get to court, though, you want to make sure that you check in. Some courts are going to just have you check in with the clerk. Others are going to ask that you wait for a docket call. If you're not sure which procedure the court uses, just ask a clerk. They'll give you more information. Once everyone's checked in and the trial actually starts, the judge is going to come out. Some judges are going to give instructions on how the court works prior to calling the cases to trial. So we recommend listening to that. Once that's done, the court is usually going to start calling cases and calling people up to argue. Once your case is called, you're going to approach the bench in most cases, or some courts have you stand behind the bar court, but effectively you're going to be standing before the judge. The judges are generally going to begin by hearing the plaintiff's case first before giving the defendant an opportunity to respond. Because the plaintiff gets to go first, it's important just to listen and let them talk and put on their case. Some people try to interject or make arguments while the plaintiff is talking. Generally, it's better just to listen and wait for your turn. Once the plaintiff is done, the defendant has an opportunity to ask questions of them. And then once the plaintiff is done with their case, the defendant has the opportunity to basically put on their evidence. So basically tell their side of the story. And likewise, they're subject to cross-examination by the plaintiff. When you're in trial, please be prepared to answer judges' questions or provide any evidence of your defense. Far too often, we talk to people who they show up at court and they say they have evidence of one thing or another, but they didn't bring it with them. It's important that you bring any material you're going to rely on to court. We also sometimes see during trial one party asking to reset the case. Generally speaking, a trial can only be reset by motion of the plaintiff or if both parties agree to the continuance. And the code is specific that a court can't reset the case more than 7 days without the parties agreeing to the reset. So, if you're going to simply ask the judge for more time, it's probably not going to happen. So just be aware of that. At the end of the trial, the judge is going to issue a judgment in favor of one of the parties, or they might dismiss the case. Or, again, rare cases, if there's a need for reset, they might give information on the reset, although, again, that's relatively rare. If there is a judgment in someone's favor, make sure you get a copy of the judgment for review and for your files. As a general note, always be respectful for the judge, to the court staff, and the opposite party. It's going to get you a lot further than being rude would, even if you're upset at any of the people involved. Just as a final note, I failed to mention, in some cases we see people who may need specific accommodations, such as a Zoom hearing. If you need any accommodations, reach out to the clerk early. Courts have different policies on this. Some courts will automatically allow a Zoom hearing upon the request of one of the parties. Some require that you make a motion and provide good cause. So talking to the clerks and getting the information early will tell you sort of what to expect and what you need to provide the court if you do need those accommodations. Like I said, we talk about settlement agreements. Settlement agreement is an alternative to going before the court and arguing and getting a judgment. A lot of judges will encourage settlements between the parties, and some provide resources to facilitate settlements, such as either providing standard forms for settlement or providing mediators who can sort of facilitate the process of negotiating a settlement agreement. A settlement agreement is going to require the parties to agree to specific terms, although the parties get to determine what those terms are. A good agreement is going to clearly define the basic actions to be taken by the parties, and it's going to it's basically spell out what everyone's agreeing to and what happens if there's a default. If you're talking about an agreement to make payments, a good agreement is going to state the amounts owed, the amounts that are going to be paid, when they're going to be paid, how they're going to be paid, and would normally provide that the landlord dismiss the case at the end of the payments being made. And the alternate move-out agreement will provide information about when the tenant's going to move out and what happens if the tenant does not move out. Settlement must be in writing and signed by both parties. It should be filed with the court. Informal or unwritten agreements between the parties are not enforceable. Now, because terms have to be specific, something to keep in mind if you're in one of the courts that have standard forms is that the forms are going to contain specific language, which may or may not be applicable to your specific situation. I've unfortunately seen instances where someone believes they're signing a form that allows them to pay concurrent and stay, when in fact they're signing something that instead requires them to pay and then leave by a specific date. You always want to review what the terms are. And if the standard forms don't work for you, you need to feel free to alter them to meet the terms that you guys are agreeing to, or feel free to write it out on your own. I can say, as an attorney, I've had more times than I can count, had to write out a settlement agreement on a legal pad so we could get the specific terms on file rather than using one of the general forms that didn't speak to the circumstances we were looking for. So just be aware you're going to want to make sure that the agreement is consistent with what you're agreeing to. Finally, in addition to making sure that you know what you're agreeing to, make sure that you can actually meet the terms of the agreement before you sign any agreements. I see too many instances in which somebody agrees, for instance, to a move-out date without knowing that they can move out by that particular date. Keep in mind, these settlement agreements, if you sign them, they could waive your right to a trial or to raise defenses. And you could be leaving real valid defenses on the table, or you could be shortchanging yourself on time you'd get. So, before you're ready to sign a settlement agreement, you need to make sure that you have plans about how you're going to meet the terms of the agreement. Now, let's say that you've gone to the Justice of the Peace Court and you've gone to trial and you lose, but either you disagree with the judgment or you need some additional time. There is an appeals process allowed under the current code. Basically, they're required that within 5 days of judgment, you file either a statement of inability to afford court costs and fees, or that you pay an appeal bond. Most people appeal via the statement of inability to afford court costs, simply because most people cannot afford to pay, the appeal bond, which is normally set at 2 months of rent upfront. So within 5 days of the judgment, you file this form with the clerk. After filling it out, the information providing is basically basic information about your income, your assets, any debts you have, and you're pleading you can't afford to pay that appeal bond. If you don't file that form within 5 days, the judgment becomes final, and the writ of possession, which is the document that the landlord uses to remove you from the property, at that point, that can be issued. So those timelines are pretty tight. You need to make sure that if you want to appeal, that you're appealing within those 5 days. Now, if you are appealing a non-payment of rent eviction, the code also requires that within 5 days of filing the statement of inability form, that you make a payment of 1 month of rent to the court registry. A lot of people are confused about what sort of the reasons behind this. The registry payment is meant to pay for current rent while the appeal is going up to county court. It's not about paying back rent. And so the judge, in addition to saying the appeal bond at trial, will also determine the amount to be paid into the registry. That information will be on the judgment itself. So it's something to look at. Once the SOI has been filed, it's important to note too, they can be challenged by either party or the judge if they believe the information contained in the statement of inability is incorrect. If the statement is challenged, you're going to want to talk to an attorney for more assistance. Once the appeals have been filed, and once you've either paid into the registry or not, case is going to be transferred to the county court at law and assigned to a court. Keep in mind, this is a different part of the legal system. Instead of it being based on which precinct you live in, all eviction appeals are tried downtown at the county courts. So you're going to receive paperwork from a different clerk's office than you would the first time, so you want to check your mail regularly. The information from the court may state that you're required to file a separate answer. If you file a statement of inability to afford court costs, you're technically protected from defaulting in the case, but you may want to file an answer anyway if you intend to raise any affirmative defenses, which is basically alleging anything more than just, I disagree with the landlord's assertion that they gave me the right notice to vacate and that I didn't pay rent, or that I breached the lease, or something to that effect. As we mentioned, for non-payment of rent cases, they require the payment of the first month of rent to the court registry. They also require monthly payments to be made. So you're talking about, for instance, right now we're in June. If you were to make a payment to the registry this month and your trial's next month, you'd be required to pay, and not again, 1 month of rent in July to pay for July's rent. Failure to make these payments doesn't actually affect whether or not you can appeal, but it does mean that the landlord can get a writ of possession early. So they don't actually have to wait for the final trial. They can rely on the failure to pay those amounts in getting their writ of possession. Once you get to county court, the case is heard from the very beginning. So we call that a de novo appeal. County courts use formal rules and procedure, and they use formal rules of evidence. It's important to note that because these procedures are uniform between the courts, a lot of this is going to look similar whichever court you're in. And, it's a much more formal process, and the rules are a lot more strict. You want to keep in mind that because the case is being heard all over again, you're not required to give a recap of what happens in the Justice of the Peace Court. You should pay attention to what the plaintiff is doing, because if they attempt to give evidence that they didn't file with the court, that's not allowed. And even if they file it with the Justice Court, the fact that they didn't file with the county court may be grounds to dismiss the case. And so, you want to pay attention to what they're doing, and you want to keep in mind they still have to prove up their case with both testimony and evidence. If they fail to do that, then you want to be able to move for judgment in your favor. As always, keep in mind that although this is a formal process, the judge is going to balance accommodating the pro se litigants, pro se meaning they're on their own. They're going to have to balance sort of those needs with following the procedure and evidentiary rules. And so that's sort of a balance that you'll see if you ever watch one of these trials. You're still required to follow the proper procedure, but the judge may cut one side a break in order to, try and facilitate them putting on their case. Because it's so formal, you may also want to talk to a lawyer before taking one of these cases on. And I know our firm, we do represent people both in justice court and also in county court. Let's say you get to county court, though, and you're unsuccessful in terms of getting a judgment in your favor, and the other side gets judgment. A lot of people wonder what the timeline looks like there. The court has to give you 10 days to pay an appeal bond, though the writ of possession can be issued within 5 days. Most courts will not issue the writ, though, before that 10-day period to pay the appeal bond. The cost of appeal from county court is usually about 10 months rent, due in a lump sum. And the appeal to the Court of Appeals is not a de novo appeal, which basically means the Court of Appeals is simply looking to see if there are any errors. In most cases, there's not grounds for most cases, there are not grounds for an appeal simply because there may not be a record if somebody didn't request a record, or, even minor errors may not be enough to overturn the judgment. So be aware, in most cases, county court is the end of the line for the eviction. It's also important to note, some courts may allow an immediate writ of possession to be issued if the monthly payments are not made, although I believe the judges will only do that if a motion for a default has been filed prior to the trial date. So just be aware, in most cases, if you're current on your payments, you have 10 days to leave before the landlord will get their writ. But if you haven't made those payments, the landlord has filed something for a default, they may be entitled to immediate writ of possession. Turning briefly to some special cases before we move off of evictions altogether. Public housing and subsidized housing tenants often have more rights than those who are simply in the private market on their own. Some of the programs that provide special rights include the Section 8 Housing Choice Vouchers, low-income housing tax credit properties, or even just regular project-based housing. These requirements are going to be spelled out in the HAP contracts and federal regulations. These can differ from program to program, but it's important to review both the addendums of the lease agreement as well as the federal regulations to see what additional rights you have. It's really important to review those too because an eviction involving public housing benefits might also involve the termination of those benefits. So it's important that those cases are handled correctly. Public housing beneficiaries, they're always going to be CARES Act properties. So if you're in one of those properties, you want to be on the lookout and see if you got the proper notice to vacate. There's also usually a VAWA notice that's required to be delivered in those properties. So pay attention to, outside the notice, what sort of additional information you're being given. Additional note, public housing beneficiaries in non-payment of rent appeals are only responsible for paying their portion of the rent to the court registry. If the court orders the full amount of rent be paid into the registry, the tenant needs to contest that order within 5 days of judgment and basically provide the court information that they are required to pay a smaller amount under a public housing agreement. Once that's been filed with the court's supposed to hold a hearing on that issue, although there are some courts that if you provide the award letter and they see that there's an issue with the judgment, they may fix that on their own motion. We call sua sponte. This is another instance in which, because these cases are fact specific, because it matters what type of subsidy you're getting. If you are receiving public housing benefits and you end up in an eviction situation, you want to talk to an attorney and see how they can help you protect your rights. Turning briefly to what happens outside of the evictions when a lease is breached, there are two sorts of things that we see from landlords. We call these self-help remedies. Both of these are generally unlawful, although there are some specific exceptions, and we'll talk about those. The first thing that might happen is the landlord might lock the tenant out of the property. When the landlord locks the tenant out of the property without basically making plans to allow the tenant back in the property, that is a wrongful eviction, and the landlord can be sued for that sort of lockout. The other thing we might see is the landlord might lock someone out, but provide information on how to get a key to return into the unit. There are rare circumstances in which that would be allowed, and we'll talk about those. As a general rule, though, landlord can't intentionally exclude you from the home outside of the need to make repairs, construct an emergency. If the unit's abandoned and they're removing contents, they might be able to exclude you from the home. Or if, again, they follow the procedure provided on the property code to change the locks, but then provide the tenant a new key. They may also exclude if judicial process allows. So that's the writ of possession. The other thing that we sometimes see is a landlord who shuts off the utilities. A landlord cannot intentionally interrupt your utility service unless it's for repairs, construction, or emergency, or unless shut off is authorized by the property code and all requirements are followed. These are kind of similar, so I'll go through these briefly. But if the landlord violates either the property code by locking you out improperly or by shutting off utilities, there is a procedure for getting a remedy here. These are, we call ex parte lawsuits, which means that you don't need to serve your landlord before you get relief. You simply go to the court, you file your lawsuit, and then you get an emergency hearing before the judge. If it's a lockout, we call that a writ of reentry. If it's utility shut off, we call that writ of restoration. These lawsuits are filed in the precinct where you live. There is a requirement to pay fees, although you can actually get those filing fees waived by filing the inability to afford court costs. It's actually the same form that you'd use to appeal the eviction process. It's just used in a different context here. For a lockout, if the lease agreement allows the landlord to lock you out, the landlord has to provide advance notice, and they have to provide a way for you to obtain a key within 2 hours of making a request for a new key, regardless of time of day, and they cannot demand payment in exchange for the key. This is why we don't normally see lockouts done, is because, if you make a request at 2 a.m. to get a new key and the landlord isn't able to get it there by 4 a.m., they're in violation of the code and they're subject to liability under the code. If the landlord fails to let you in and you're locked out of the unit, the first step is the writ of reentry lawsuit. You draft the petition stating the facts of the case under oath. You would sign a verification stating that, you're verifying the facts contained within the petition. Once the case is filed, you call the clerk and you get an ex parte hearing. You don't need to serve your landlord, but it is good practice to put them on notice that the hearing is going to be held. So either sending them an email, calling them, some other way. That way you can tell the judge you tried to talk to the landlord and they wouldn't let you in and they didn't show up on their own. The judge is going to hear the case, which basically requires that you basically tell your story. If the judge agrees you're legally locked out, you receive a writ of reentry order that requires the landlord let you back into the property. That is going to be served by a constable. Once the constable gets the writ to the landlord is required to let you back in. They also have an opportunity to contest the hearing, but they have to set a different hearing date for that, and it's time barred. So just be aware, there may be an additional hearing in which you tell your case to the judge again, and the landlord, might contest some of your facts. So make sure that you document what's been going on while the case is ongoing. Outside the writ of reentry, once sort of you're back in the property, you can file a separate suit for damages. The penalties for that are 1 month rent, $1,000, any actual damages you have, court costs and reasonable attorney's fees, less any amounts in delinquent rent or other sums. There's also a requirement, also an option that a tenant who's been locked out and is suing for the wrongful lockout, they can also terminate the lease agreement if they so wish. Utilities are fairly similar in terms of the process. You're going to file a writ of restoration lawsuit in the precinct where the house is or the apartment is. You file your petition that you verify under oath. You set the case for ex parte hearing. You don't need to serve your landlord, though it's good practice to let them know what's happening beforehand. The judge, if they agree that the utilities were illegally disconnected, will give you a writ of restoration, ordering the landlord to restore the utilities. They then serve it on the landlord who has to restore the utilities. And then the damages recovered are very similar to what you would get as far as a lockout is concerned. Recovery actual damages, 1 month's rent, $1,000 in reasonable attorney's fees, less any delinquent rent or other sums owed to the landlord. Briefly, before we move on, something I should have emphasized a little bit more. As you're going through this process, you want to document your damages. Loss of any property, any expenses such as food or water or hotel stays that you might incur due to the lockout or the shut off the utilities, because those all feed into the damages that you can get. A lot of people don't do this, and then they're sort of barred to the $1,000 along with the 1 month of rent, when in fact they've incurred far greater costs. So just be aware. Documentation, this is our area where that's the name of the game. There's one final thing before we move to the end and questions. We do get questions about what happens to security deposits when you're dealing with either an eviction suit or at the end of a lease term. Security deposit is kept in order to cover any damages the landlord might incur to the unit. Landlord may keep or deduct those amounts if there's physical damage to the property, or they may keep those to cover any arrears that might have risen. So for instance, if you're behind on rent, the landlord can deduct the amount that you're behind from the security deposit instead of returning that to you. However, if there's still amount that are left over in the security deposit after all of that's been taken care of, the landlord is obligated to return the deposit. So landlord is required to return that on or before the 30th day after the tenant surrenders the unit and provide a forwarding address. They can't retain any portion to cover wear or tear. And if they are going to keep any portion of it, they do need to give you a written description and itemization of any of the deductions. In order to get the security deposit back, like I said, make sure that you have a good forwarding address for them. Well, let me phrase that. Make sure that they have a good forwarding address for you. It's always best practice to give that to them in writing. If the landlord does not return the security deposit timely, our recommendation is to send them a written request for security deposit. And if they still don't respond, at that point, there's a lawsuit that you can file. And that's another instance in which you're going to want to seek the advice of an attorney. And I will say, there are stiff penalties for not timely returning a security deposit, and there are certain presumptions that are very favorable to the tenant if amounts aren't returned timely or if they don't provide the itemized list of deductions. So that's an area where, if you can get an attorney, that's usually best practice. And just some additional tips before we finish. All of these issues usually arise because there's some problem with communication. We always recommend that as soon as a problem arises, that you speak to your landlord. It gives you a chance to get ahead of it, or if the landlord is being unreasonable, it gives you a chance to sort of plan ahead, knowing whether or not they're willing to work with you. If you are behind on rent, there is still some rental assistance may be available. We recommend checking with local organizations. The courts also have eviction resource coordinators that you can talk to. So if you want to speak to them, you can contact the court, or if you go down during a docket day, they'll be available to talk to you. If you're having issues with the condition of the unit, if you have repair issues, again, just to emphasize this, pay your rent and then contact for someone for help. Don't withhold rent. Make sure that you're documenting everything along the way. That can help you out in the long run. And then, if you need assistance, we're here. There are other organizations that assist tenants in landlord-tenant disputes. So just reach out to us and, we'll see what we can do. And that's the end of my presentation. We have some online resources for you. Texas Law Help is a website that provides information to pro se tenants. If you have any questions or want to apply, our website is here. And so is our office number where you can call in to do an intake. So that's all I have. I'm ready to take questions.
Okay, let's see if I've got any in the chat here. If I've asked for months for repairs to be made concerning pests and landlord isn't fixing the issue, is it advisable to pay early termination uh, fee from the lease and give 60 days notice and to claim taken to claims court later to get the funds back because they broke the lease?
That's a bit of a specific question, but I'd say generally that's not the procedure that is used under the code. Normally the way this works is that you provide them written notice. We recommend via certified mail because that can shorten the timeline. The code requires that there be given a reasonable amount of time to fix whatever the issue is. Reasonable is presumed to be 10 days, although it could be longer if there are circumstances that make it longer. So for instance, if you have hurricane damage and the landlord can't repair it within 10 days because there's no contractor available because they're all working on other projects, that might be an excusable reason why they can't repair it within 10 days. If, however, they don't repair within a reasonable amount of time, and they don't fix the issue within a reasonable amount of time, at that point, you might have a cause of action against them, either for damages for an order repairing it. I think in some cases you might be able to petition the court for the termination of the lease itself. But this is an area where I think this is a fact-specific issue. I think you should talk to an attorney who can help you with sort of documenting the damages, documenting what steps you took to get the landlord's attention. Having an attorney might help if the landlord tries to retaliate. I mean, retaliation is illegal, but you do sometimes see it, and even a simple eviction filing can hurt a tenant. And so they can help you through the process and get you a better outcome on the other side, rather than just paying the early termination fee and trying to make an equitable argument that the fee should be returned because there were issues later.
Is it from what I read just now,
Mhm.
is it advisable to pay the early termination fee from the lease and give 6-day notice and take them to small claims court to get the funds back because they broke the lease? Did they in fact break the lease? If you're agreeing to, I mean, would that be considered them breaking the lease if they if the tenant decides to move out and pay an early termination fee?
I mean, generally speaking, this is another thing to keep in mind, is that the lease agreement, there are obligations the tenant has to meet, but there are also obligations the landlord has to meet.
Mhm.
So a good lease will contain information about who's responsible for repairs and when things are to be done. Some may require notice in a particular way. The code does allow some forms of repair to be the rights to those repairs to be waived, although um, generally speaking, if you're talking about a condition that materially affects the health and safety of the tenant, the landlord can't waive that. Um, but yeah, if the lease requires that your landlord make repairs and they don't make repairs, I think it's fair to argue that they broke the lease. Now, keep in mind there's a procedure for enforcing your rights there, and it's not, you want to follow that procedure as opposed to either withholding rent or trying to make something up on the way. This is why I think you should talk to an attorney, is that they can speak to the specific facts, see what sort of documentation you have. If you don't have the right documentation, help you to get that documentation. And then if it does come to actual litigation, they can assist you with that process.
Okay. That's all the questions that's in the chat. Let me check my email here. I did have a question in the meantime while I'm looking this up. Um, when it comes to making the payments, your monthly obligation, your monthly payments, can a landlord require that you only have one form of payment? Like, for instance, if they put in the lease that you can only pay online or through a portal or something like that, where they charge you additional fees to make those
Yeah,
payments. Are they
I know.
required to give you multiple options?
I know we've gotten this question before. I still don't have a good answer. We've talked about looking at junk fees or looking at different forms of uh, authority to say that you shouldn't be required to pay, fees in order to pay your rent. I don't have good authority to answer that question. It seems ridiculous that a landlord both require that you make payment in a particular way and then charge you a convenience fee for that payment. But I don't know if there's any litigation or any authority which might prohibit it. It's something I would imagine that our consumer unit might want to take a look at, but I don't have good answers for that.
So in that regards, if for whatever reason that it is allowed or what have you, that they only have that form of payment, but then they make a condition, like every once in a while or whatever, they'll allow you to pay uh, money order or in person or something to that effect. And then later on decide, I'm not taking that form of payment anymore. Is that legal grounds then at that point where they can refuse your payment, even though they've accepted that form of payment in the past?
Good question. Um, Generally, the lease agreement controls. That said, there might be a strong equitable argument if you tendered your payment one way habitually, and then they refused to take it, and then you were late because they refused to take it, but then you paid the next day. Or, if they refused to take it after that day and just filed for non-payment. I don't know what the judges would do with that. That's an excellent question. I've never seen anything specific like that. I could imagine making an argument that you could make the argument a non-material breach of the lease, which basically means that, yes, it's technically against the rules, but the circumstances mean that it doesn't affect sort of the reason for the lease.
Okay.
I wouldn't necessarily recommend doing that. The unfortunate thing about evictions is that there's so severe as sort of a remedy that, a test case is not generally more harmful than good. But yeah, I would yeah, I don't know that I have good answers, but it's an excellent question. I might run that past the rest of the unit.
Okay. If someone has the inability to afford court costs, can a landlord still require them to pay their court fees if it's in the lease?
Um, so generally what is required under the lease is that the prevailing party, well, actually, let me back up. Some leases have language that says that if the prevailing party covers the other side's attorney's fees, court costs, or what have you. Um, the general rule for court costs is that the party that bears them is the party that does not prevail. And so while statement of inability to afford court costs, might allow you to waive your own court costs, I don't know that it would prevent someone from trying to collect on those. That's a good question too. I've never seen that one play out quite that way. But I'd imagine that even with a statement of inability, the court is still going to assess court costs against the tenant if they lose.
Someone's typing out a question, but if you feel better unmuting yourself, you can go ahead and just unmute yourself or raise your hand, and if it's easier versus typing out the question for the Zoom user that's on. Another question here. Will the recording or presentation be shared with us? Yes, it will. At the end, I will send out a copy of a link so that you can go back and view. You can also go to our YouTube channel, and that link will be on the email for you as well, so that you can go back and view and possibly share with somebody else that may also find the information to be beneficial too. Let's see. In our notice to vacate, it states.
I'm looking at that.
Oh, okay.
Zoom user. I would recommend applying for services. I am not going to answer that question because it is too specific and because me answering that question could waive attorney-client confidentiality.
Oh, yeah.
It's something, let's say, it's something that looking at it, someone might be interested in trying, but I'm not going to comment on it here and now. So, I'd recommend calling our office or, I guess the only thing is, yeah, I would say just reach out to us and someone should evaluate your case either through our intake unit, or if it gets assigned to one of our attorneys, they can assist you at that point.
Okay. That was in the de novo case, though.
I'm not going to answer you specific questions about that fact pattern.
Okay.
It's not personal. It's just.
Yeah, we did go over that in the beginning. If you have some real specific questions that we can't get into a whole lot of detail about a specific situation, that it has to be like a general kind of question, because we are on the public platform, so we don't want any of that information kind of getting out there. You want to say your number again? No, that's okay, not a problem. You want to say the number again for
Yeah,
them
I'll
to
put
reach?
in the chat, but
Okay.
actually can I share again?
Yeah, go ahead.
Okay. Yeah, I still have the slide up. Okay.
Okay. All right. So for those folks that are on YouTube too, they should be able to see that. So, let's see what other question. Just want to make sure that I get everything addressed. Blah, 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 blah. Let's see. Find lawyer for case if it's legal. No. Okay, that was you. The difference of a criminal eviction. I don't understand what that question means. What's a criminal eviction?
I don't know.
Okay, I've never heard of that either.
I mean,
Uh,
are they talking about unlawful evictions by the landlord where they
I,
lock someone out
I
improperly, or are you talking about?
I don't know. That's somebody that's in Austin that sent that question. So I'm not sure if that's something that's going on in Austin or if it's something that they know about that's a little bit broader.
I
Uh,
mean, it could, I don't know if they're talking about, like I said, the unlawful self-help, or if they're talking about conduct-based eviction for alleged criminal actions. Like those are the only two times.
okay. Can a roommate unilaterally terminate the lease?
That's a good question. That's a good question. I actually don't know.
That a it
That,
depends question.
well, I wonder, that may be an instance in which it might be beneficial to talk to the landlord and see if there is some way to negotiate. Because that's almost more of a practical question, a legal question. I like the legal side of that is, if you're a party to the lease agreement and you have authority to terminate the lease, you do so without the permission of the other, but you still have that agency and that authority, then yeah, you could probably terminate the lease. Um, if it was an early termination, depending on the circumstances, it may be something where you talk to the landlord and say, well, he wants to leave, but I want to stay, and I'm covering the lease as it stands. Or if it's at the end of the lease term, there may need to be a new lease agreement for that person, but obviously that's subject to the landlord agreeing to, allow them to stay. I would speak to a lawyer about the specific circumstances there. I don't know if there's a single answer to that question.
Yeah, I would imagine that if you had two people on a lease, and I'm speaking from the realtor perspective, if you had two people on one lease and somebody then tries to terminate, then the person that's remaining on the lease would still have to then qualify or to apply separately on their own. So I don't know that they would be able to, especially if they were relying on that other person's income
Yeah, I
to
mean,
give them access to the, for the
yeah.
unit. But
I mean, there may be reasons why talking to the landlord and like negotiating to stay, but at the same rate might be inadvisable. Again, I think it's very fact specific, and I hesitate to give much more information again, just because there's so much variety of terms of the scenarios that I don't want to say one thing when, different answer in different scenario could apply. So that's one where you're going to want to talk to an attorney if possible with sort of specific questions.
what if the landlord finds out after a tenant has moved in or after a rental that they have a criminal background?
Um, Most landlords will well, I shouldn't say most. A lot of landlords will require that you disclose your criminal history when you apply. And so if they're relying on, criminal act from the past that you did not disclose, arguably that's a breach of the lease, and that could lead to an eviction. Um, if you disclosed everything and they just weren't paying attention and then they found out, oh, this guy's a criminal and so we want them out, that's not really a breach of the lease. A lot of landlords will also use tenant screening to identify if someone has a criminal background or not. Um, so, if they didn't ask and they made a decision and they find out later that this person had been convicted of something, but they didn't ask and was in condition, that's not a breach of the lease. So it depends on what sort of disclosures were required up front and whether somebody lied. At least that's how I would try that particular case.
Okay. Let's see. To be clear, you had said that the landlord cannot use your security deposit for late rent, or is that allowed?
Um, I don't think I said that, but just to clarify, the landlord can deduct from the security deposit any amounts that would be owed, as well as amounts to cover damages to the unit, so physical damage other than wear and tear to the unit. And so, yeah, the landlord, if you get evicted and they have security deposit, the landlord could retain the security deposit to cover late rent. What you should not rely on as a tenant, though, is that if you're paying late, that the landlord simply can deduct, what you didn't pay from the deposit. The deposit is specifically there to cover damages on the back end. If a tenant is like pleading that they shouldn't have to pay because they made the deposit, I believe the code actually allows for specific damages to be assessed against the tenant. So it's something that the legislature took very seriously when drafting the code. So, I mean, simple answer is they can keep it if you're behind on rent, but you should not look to security deposit to cover any amount that you didn't pay on the front end.
Like if you decide to move out early and not pay your last month's rent and think, oh, they got the security deposit, they can just keep that and,
Yeah.
yeah. Why is it legal for landlords to request someone's social security number on a lease application?
Usually the reason they're asking for social security numbers is because they're going to be running a background check or a tenant screening check, and that information allows them to identify, you know, whether somebody has a good rental history, bad rental history. I mean, I don't know what ground would be illegal for someone to request a social security number. I might have to ask our consumer people about that, but like if you're wondering why someone asks, as part of an application that you provide that information, it's about that background check.
And also, if you tend to skip out, they need to know how to report it, how the collection agency then needs to report it to the credit bureaus. So they have to have that as well. But
Yeah,
just be careful about who you're giving your who you're filling out an application for, because I know that there's a lot of fraud that's out there. There's a lot of folks that put misinformation about available properties that are out there, and then you just go and randomly decide to submit an application to somebody, and you have no idea who it's actually going to. So be careful when you are filling out applications, and um, especially like on people rent those units like on Facebook or Craigslist and all of that kinds of stuff. Just be careful.
yeah. Um, I mean, as a rule, if you can avoid giving them the full number, I think that's helpful. But yeah, I mean, I don't know a reason why they would be prohibited from taking that number. I mean, certainly if they take that number, they use it for bad things, that's a different issue. And certainly
Yeah.
that's actionable, but yeah.
Yeah.
Did I
I
just
believe those
here, stop sharing?
there isn't on that screen there wasn't a phone number for Lone Star.
Oh no,
Lone
there
Star.
was. Sorry.
Is there?
Yeah, let me go back.
I
It's
saw
the
the
very
email.
bottom.
Oh,
713.
713.
Yeah.
Okay.
Let me
713 652 0077 or 1-800-733-8394.
mhm.
Okay. Well, those are all the questions that I had emailed to me, and as well as on our social media pages too. Oh, you know what I wanted to ask about? If you could
I
touch
have
on real
one
quick.
more question.
Oh,
Oh, I see. See the
oh,
retirement amount on your pay stub? That could be about, I mean, keep in mind, I don't work for the landlords, so, whatever they're thinking is what they're thinking. I'd imagine that is about,
that's an income that would be an income
it
qualifier.
might,
So,
yeah, it might be an income qualifier. It might also be, again, if they're looking for,
wait,
you
wait,
know,
let me ask. retirement amount as in what you have in your retirement plan that you get from an employer?
You know, on your pay stub, how it shows all of your personal and
Deduct-
private deductions?
Yes.
The lady was telling me she redacted a lot of that information because she thought all the landlord needed to see was her income. So the landlord got upset with her and said they needed to see all of what deductions were coming out of her check. So she told me to ask. So I told her I didn't think it was relevant.
I don't think it's relevant.
It's not.
That said, the unfortunate thing is landlords, I think, have a broad discretion who they rent to. I don't know that it's actionable if she was denied for redacting those things. It may be worth talking to a consumer attorney. I don't know if there's a DTPA issue there. Probably not. There might be something else, but no, I've never seen that fact pattern. I mean,
Well, unless they also thought it was a fraudulent check stub that was produced, since it was manipulated and not the actual, you know,
No, no,
stub as it was.
I think it was just the landlord going above their authority to ask, and they didn't know.
I
Yeah,
mean, it might be. I don't,
possible. Yeah.
again, I don't know that there's anything that specifically prevents them from asking for that information. If they ask and then you don't give them the information, they deny you the application. I don't know that that's something that you can turn around and sue them over, but um,
And
yeah,
I
I
would
don't know why they would.
and I would imagine that would be a very clear sign of what kind of landlord you're about to start dealing with. So I probably wouldn't rent from them in the first place if they're giving you
Amen.
that
And
issue.
that's what I told her too, Nia.
Yeah,
Right.
yeah, no, that 100% agree. If
Yeah.
you're applying for a place and the landlord seems unreasonable up front, you might be setting yourself up for, a bad time. And so,
Is there any reason a landlord could refuse a new tenant joining another tenant in the middle of a lease that doesn't have a criminal background and that was approved on a property and lived on the property years earlier?
I mean, generally speaking, a landlord, does not have to give a reason for not renting to somebody. And if you're talking about a new tenant joining the middle of a lease, I don't know if they're considering that to be a sublet situation or, I don't know, but again, they're not required to give a reason why. They can decide basically they just don't want to deal with this person.
Yeah,
And,
or
I mean, it could have been a situation where the reason they were renting from the property and left was because things went bad or there were issues there. But that said, I don't think that that's an actual scenario. If you want to give more information, you may want to, again, reach out to an attorney who can vet the specific facts in that case. But yeah, landlord can't be compelled to rent to anyone in most cases.
plus, isn't that altering their existing lease? You're basically trying to force them to alter a lease that's already in place, right? If you're trying to get them to add a new tenant to an existing lease, if there's
Um,
already a lease that's in place and you're asking them to add somebody on,
yeah,
that's kind of changing
I
the whole
mean,
concept.
it can be. I don't know how most landlords would look at that, because usually if you're adding somebody on, as long as there aren't any issues, it might just be another income. But yeah, like I don't think they have to give a reason for saying we don't want to make this change or we don't want to let them live here.
Yeah. Okay. Great
Okay,
suggestion. The Consumer Protection Bureau.
yeah.
If the final person, we should be able to say who would be illegal.
Zoom user, if you want to call again, there is a complaint process, to get your case sort of looked at by somebody above our intake unit. Um, I can never guarantee services for anybody. But that might be, how you get someone's attention to just, have the case looked at again.
They were accepted already, said email said that there wasn't enough staff.
Um, yeah, I mean, we do have a limited number of staff. Again, my recommendation, if you think that the case, didn't get a close enough look or so you get the information. You can always go through the complaint process to see if, somebody above wants to take a look at it and provide additional services.
Says this person is paying for the lease already in the same household. If they're paying for it and they're in the household, I guess that means that they're there illegally already.
It could be an unauthorized occupant situation. Yeah, I don't know they want to dig any further into that.
Okay. It's done all the time in low income communities. Okay, I did a
Yes, what happens is a lot of people move in, and landlords that don't really know the law allow it until something goes wrong. And then they
Yeah,
say, well, they're not on the lease, but you've allowed them to live there. You know how
yeah.
they
If
may charge them, Nia?
I'm sorry.
so, go
Say that
ahead.
again, Miss Allen.
You know how in some low income areas they know the relative is there. They may charge them, I'll say, something extra every month. Everything's good until it's not. And then they throw in their face where they're not on the lease and that you're violating your lease. And it gets real tricky because they're not consistent. They're not
Yeah,
consistent, is the problem.
I mean,
They
it's
can
going to
use
be a
their own.
fact. Sorry, it's going to be a fact-specific issue. If this is a situation where they have actual knowledge this person is there and they're charging the tenant something additional to allow them to stay, I think it's hard to turn around and argue to a court that that person is an
Is
unauthorized occupant when you've
yeah.
basically not only carved out the ability for them to stay, but also charged somebody for the privilege.
Correct.
Yeah, so that would be a case that I would love to take a look at, if that fact pattern ever comes up. Haven't actually seen it, but yeah, I do believe that there are instances in which, you have unauthorized occupants, and it's fine until it's not, and then the landlord takes advantage because they didn't add them to the lease. But
Right,
with that,
Benjamin. Correct.
yeah, but with that said, as far as compelling them to add them to the lease, that's not a thing.
Mhm.
Right.
Okay. Are there any other questions? Great questions for this, for such a small group that's joining us today. It's great. Is there any? Oh, I knew what I was going to ask you about. Um, the landlord taking property out of a unit. Can you touch on that, or like what's allowable and what's exempt from them being taken when people are behind on their rent?
I don't have the exemption list in front of me. Landlord lien needs to be authorized under the lease first and foremost, and a lot of leases don't have that provision. If they don't have a provision that gives them the right to take property to cover those amounts, then effectively they're not allowed to take property out from the property. If they do take it, my understanding is that there's a broad range of property that's exempted from the lien.
Mhm.
It can be everything from clothes to work materials to, I think there's an exemption for the library that the tenant has. So they can only take specific objects. And then they actually have to take good care of the objects because the idea is that they hold the objects and then you pay to get the objects back. That said, it's something that if you're facing that issue, you should talk to an attorney and review the code.
What can renters do when the landlord is a violator and reporting it to the owner will definitely cause retaliation? You mean landlord as in a property manager company or
I'm not sure I understand what you mean by,
a violator?
yeah, by landlord, by violator. I mean, owner seems fairly self-explanatory. I'm assuming by landlord, you mean property manager, staff. I don't know what the violation is.
Yes. I think she was saying, I'm typing like Nia. I think what the lady's saying, there's an alleyway to the apartment. You're not allowed to park in the alleyway, but the I'm reading here, but the landlord, the property manager, in our area, Benjamin, they call them landlords. Same thing. Property manager. they park in the alleyway, and when their relatives, if I'm reading it right, and their relatives park in the alleyway, but if the renter parks in the alleyway, they're the landlord tells them they can't, and then the owner contacts them and says they can't do it. If that's making sense.
If it's part of
Um,
their property, I mean, they could have parking restrictions for everybody else.
yeah,
And I think that's what she's saying, Nia. Everybody is forced to follow the restrictions, but the landlord is the one violating because they're the landlord. You follow what I'm saying?
I mean, it might be that, I mean, I don't know. It's gone from being too vague to now a little bit too fact specific
Gotcha.
to deal with.
Gotcha. Okay.
I will say, community rules are for the tenant. Um, the landlords themselves, like the property managers and such, they may not be obligated to you to follow the same rules. And so, if there's like
Because
a
it's their
prohibition,
property.
yeah, now that's not to say that you would have no recourse if there were like legal or civil issues going on. So, for instance, if you're required to be courteous, but the landlord's harassing you, you may have other legal avenues to get that dealt with. But I think, I mean, parking regulations, I don't think that the landlord is required to follow the same thing, the same sorts of rules as the tenants. And it may even be that the reason the parking restrictions exist is to give the landlord the right to park there. I don't know.
I just put it in the chat. She said when the landlord has parties, they park in the what is it called? Alleyway, driveway.
I
Yeah, and that's
I don't
still at the
know.
discretion of, I would imagine that's still at the discretion of the landlord. If it's their building, they're the owner, they're
No,
authorized to do
they're not the
whatever.
owner. They're
I
not the
said if
owner.
they are, or they're authorized by the owner to
Oh, gotcha. Okay.
do
I'll
what,
let them know. Okay.
then yeah.
Yeah. Um, you know, if you want something more specific, our information's up there. You can apply for services.
Okay. So, Miss Allen, do you have additional people that are there with you that are tuning in, or
No,
did you say you were
they're
reading?
texting me.
Hmm.
Oh. So you're
Yeah,
watching
so I'm
Zoom
trying.
via text for somebody else.
Yeah. So that's how I don't have enough information really. They just say, "Hey, can you ask him this?" I'm like, "Oh, okay."
Okay,
Sorry.
gotcha. Well, thank you for that. And I will send out. I'll include you on the email also, Miss Allen, so that you can send them either the link for the recording or the YouTube channel, so that they can go and watch it themselves as well.
Awesome. Thank you.
All right, good deal. Okay, all right. Zoom user, you are very welcome. Sorry we couldn't be really specific with you on this platform, but yeah, and definitely encourage you to kind of reach out to see what other options that you've got or what's available. So,
I would recommend following up just because, we're all running like chickens with our head cuts off, and you know, getting someone's attention sometimes requires a little bit of effort. So
and the, and
I can't guarantee services, but hopefully we can connect you with somebody who can answer those questions.
and what's the percentage? I can't remember the number. It's like 60 something percent, 70 something percent of the people in the state of Texas are eligible for legal aid assistance, but there's only like one attorney per 10,000 people or
Um,
something like that that actually are available. So I definitely know that there's a shortage.
I don't know about the percentages. Certainly the ratio, it is kind of that extreme where
Yeah.
there are a lot more people who need help than there are those of us who can help. But with that said, we do what we can to provide at least advice to everybody, if not, full service. And certainly, if there
And
are defenses, those are the cases that we're interested in taking. So,
and then I'm also gonna put in the chat. It's legal lines. The Houston Bar Association has a service called Legal Lines, and I believe they can offer you like a 30-minute consultation or something like that that they give. I can't remember. It's either like free or $25 or whatever that little nominal
Yeah.
fee is. That number is 713-759-1133, and ask for I guess an eviction attorney or somebody that they can refer you to have a consultation or at least get some more specific questions answered.
Let me emphasize too, when you're looking for help, make sure that you're going to a credible source. There are a lot of scams out there, a lot of people who, want to charge people without providing real information or real assistance. So just, Lone Star Legal Aid exists. Houston Volunteer Lawyers exists. State has a attorney referral service. I don't know what's going on with the law school clinics, but in the past they've done a lot of work on these issues.
Yeah. Oh,
You
yeah.
know,
Houston Lawyer Referral Service too. Both of those are subs of Houston Bar Association. Houston Lawyer.
Houston Volunteer Lawyers.
And I'm just putting the names in the chat so that when you guys get the recording, that the information will be there. But it'll also, those links to their different websites and information will be included on the email that goes out too. So there's a section on there about resources or available resources, and all those legal aid organizations, including the Legal Lines and Lowell Referral Service link, will be on there too. Okay. Well, I think that's about it. If there are no other questions, I think we're going to kind of wrap it up for the day. We do offer this presentation on evictions. Oh, you know what? Nope, one more thing. Benjamin, wanted to ask you about the latest update on the changes for evictions that's kind of sitting on the governor's desk waiting to be potentially made into law. Do you guys know have received any kind of updates or anything about that just yet?
So if you've been watching the news on these issues, you probably know that the legislature passed a bill that makes some rather significant changes to the eviction proceedings and procedures. We are still going through that to look at how this is going to ultimately affect our practice. Without going too in depth, some of the things that were considered but were set aside, there was originally going to be a summary disposition process for evictions. That has been changed to only apply to squatting cases. There may be some changes in how notice of vacates are delivered. And then there are some other parts of it that may come under legal challenge. So it's hard to know specifically right now what this ultimately ends up looking like, just that some major changes are coming. Next steps, what we're on the lookout for is, first, we have to wait and see if the governor signs it, which we think is either likely, or if he doesn't sign it, he probably is not going to veto it. The next step, though, is the Supreme Court is going to have to issue new rules of procedure. And that'll tell us a little bit more about what that looks like. We're then also going to wait for new standard leases, probably from Texas Apartment Association and Texas Realtors Association, see how they're interpreting these rules. Early next year, like January 1st, the rules start to come to effect. My guess is that there's going to be a wave of litigation initially while people figure out sort of what everything means. And then as things go along, we'll get a better sense of, how this is actually going to work in theory. But just be aware, some major changes are coming. Some of them are going to be friendly to landlords. Some of them, like a new right to cure, is going to be favorable to tenants. And we will read you guys in, as soon as we know, sort of get a better sense of how it's going to look.
Okay. Again, that's another reason why we keep the attorneys on so that they can give you guys the most up-to-date information, what's going on as laws change, as processes change. because some people probably don't even know that there was a bill that was out there that was even proposing changes to that whole process. But it was a lot more extreme than when I first heard it. It was like, oh my gosh, this people are going to be out on the streets if they allow that to actually be passed, because it was a lot.
Yeah, for the record, I can't comment on this from a
I
normative
know.
perspective. Well, I have to say that for public consumption. I can't comment on whether I think it's good or bad, just that it's coming and it's going to have an effect. So be
Yeah.
aware. If you're watching this in late 2025 or 2026, pull up a new version of this recording. Hopefully, we'll be dealing with it by that time.
Indeed, indeed. All right. Well, thank y'all very much for joining in and for participating in this conversation. Appreciate you, Benjamin, this afternoon for providing this information to the community. If there are any workshops or topics of discussion that you guys are interested in that we don't currently offer, there's a link that pops up on the screen after we close out the meeting. If you could just take a couple of minutes to fill out that survey and provide us with your feedback and let us know, one, if you got the information that you intended to receive, but if there was some additional questions or information that you thought that did not get addressed or wanted to address or what have you, please provide us with your feedback. We are off for the month of July. However, we'll be back in August, the third week in August. So if any of you know someone that needs to hear this information, we'll be back the third, I say the third week, the third Tuesday in August, with another live presentation from Lone Star Legal Aid. So thank you guys very much. We appreciate you for being here. If this is your first time attending, we welcome you to the month of service. And if you've come back before, thank you for your continued support. We appreciate each and every one of you. We hope you all have a wonderful remainder of your day. Take care of yourselves, stay safe, and we will see you guys next time. Thank you, Benjamin.
Thank you.